When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see it typing but nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you're always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard, magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Daniel. That's why you're always there. When the screen goes dark and the world won't start, I know who to call, yeah.
All right, well, welcome. Today is Judge Lynisse Bryant, and this is a judge you don't want to mess with. The queen of eye rolling. Actually, John, I like it. I just canceled Spectrum. I just got tired of paying $100 a month for internet that goes out during the middle of a live stream. It's just ridiculous. It's just ridiculous. I got tired of it. I got tired of Spectrum. And then the price kept going up and going up and going up and going up and going up. They tried to offer me the same price as what T-Mobile was offering. I said, I'm not interested. I'm not interested. It's a lot faster. My upload speed is a lot faster. But let me get on with Judge. Let's get on with Judge Bryant. No, I got the $50 a month. I'm not worried about the extra money. It's half of what I pay now. I got tired of paying it.
Mr. Applebaum, can you bring your camera up? Like we're literally like looking up.
I'm in my car, but I've got my iPad with me, and I think that should work out there.
Okay, yeah, that's better.
I'll hold it up.
All right, I'm ready on date. Excuse me, I'm ready on Davis. This is case number 235546801, the people of the state of Michigan versus Michael Anthony Davis. The defendant is charged with 1 count of malicious destruction of property, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Alan Applebaum on behalf of Mr. Davis.
Your P number, counsel.
36444.
And Mr. Davis, your name for the record, your full name. Unmute.
I reversed advanced macular degeneration, and here's exactly what I did. It's called the astronaut trick.
Michael Anthony Davis II.
Thank you. Today is the date set for sentencing. I've had an opportunity to review the pre-sentence report, but I think this was a case. Remind me, is this the case that Mr. Smith was handling at first?
Yes, Your Honor. If the court recalls, my client took a plea in front of Judge, it was Judge King. I forgot. It's in front of, I have the transcript here, but he took a plea in front of another 36th District Court judge. At that plea hearing, Your Honor, my client had met with Mr. Marvin Smith, who was attorney at the time, and the assistant prosecutor at the time. And my client believes that they made an agreement that my client would plead guilty to the charge, immediately pay the restitution for the items that were allegedly damaged, and then probation would be immediately canceled, I guess, if that's the right word.
Yeah.
The matter transferred to you, and then at a hearing.
Okay, go ahead, counsel. I'm sorry.
At a hearing a couple of months later, my client, you had indicated that you thought that you might not give that type of sentence because you had not taken the plea and you were not part of that agreement. I had indicated that my client had indicated to me that agreement had been placed on the record in front of the other judge. I did purchase a transcript, Judge. I do have the transcript, and that was not it was not really placed on the record.
No, it wasn't. I knew it wasn't. When he said that, I knew it wasn't, but go ahead.
Right. I mean, basically, I can read to the court. It says here, when Mr. Davis said, I thought that this was, that was going to be the deal. The court said, all right, if I can't tell you what Judge Bryant is going to do, I can tell you what I would do in a case like this. If everything was paid off and you came for sentencing, I'd probably just close it out right then and wouldn't worry about it. So long as you can show it's paid off, your attorney can motion to have it closed out and probably will. But I can't speak for Judge Bryant, and that's where we're at. So you had indicated to my client that in theory you might, I repeat, you might allow him to withdraw his plea, but you wouldn't really make that decision until the transcript was secured and the language in that portion of the transcript provided to you. And so that's kind of where we're at, Your Honor.
Yeah. I knew that didn't happen when your client said it. Why? Because I know that my colleague who came on the bench the year before I did knows exactly how it works. So when a plea is taken in the felony courtroom, it is automatically sent to the misdemeanor court if they plead to a misdemeanor. The felony judge can only accept the plea and can never speak for the misdemeanor judge who's going to actually do the sentencing. So I knew that my colleague would not have told Mr. Davis what his sentence was going to be, because there would only be one person that knows exactly what the sentence would be, and that would be me. And then Mr. Davis's attitude was so horrible that day. I mean, it was so horrible that day. I remember it like it just happened yesterday. It was so horrible. In fact, when his lawyer came out of the breakout room, I knew that they had some strong words inside of that breakout room. And then his lawyer asked to be removed. And then Mr. Davis, he left. I think he came back, or he tried to come back or something. And his attitude was so horrible. And And then I said, well, I would consider allowing him to withdraw his plea. And then I too read the transcript. And I knew that my colleagues said what he said. And Mr. Davis heard what he heard. And that's why it's a good idea to pay attention and to be cordial in court. Because then the judge comes back and remembers the attitude and behavior of the person who's asking the court to do something. And then the court is not inclined to do what the person is asking them to do because the court remembers how horrible their attitude was the first time that they came. And I don't even think that we got to even what the terms and conditions of the probation would be outside of the fact of me letting Mr. Smith know that this isn't some just pay and go. If a person maliciously destroys property, they got an anger problem. It's something else that needs to be addressed. This is a misdemeanor. And it is punishable at least by 90 days in the Wayne County Jail. And up to 2 years probation, up to $500 in fines plus costs. So, Mr. Applebaum, how did you want to proceed?
I'd like to ask Mr. Davis if he still wants to have the opportunity to withdraw his plea. I spoke to him this morning. I didn't. We wanted to see. We wanted to go to court this morning, and he's got. And I don't need, because you had indicated the last time you were not quite sure if you'd even allow him to withdraw his plea, but you didn't make a decision whether he could or couldn't at that time. I wasn't there when Mr. Smith obviously was there, and maybe Mr. Davis was, I'm not trying to make excuses, or maybe a little bit, but I think he was frustrated the last time because, right or wrong, good or bad, he was under the impression that he thought that was the deal. That doesn't make it right. That just means what was in his mind. So I think he was a little bit frustrated with Mr. Smith and or whoever, or maybe he should be frustrated at himself. That I understand.
For not listening when Judge King clearly said, I can't tell you what Judge Bryant is going to do. I could tell you what I would do. And then that's why when he was on this docket, he was doing what he was doing. And then he wanted to be on felonies and I wanted to be on here, and we switched places. And now he can't tell me what to do and I can't tell him what to do. And that's why we're right here, right there.
But I wanted to get that transcript to show him, and he's absolutely read that transcript. So he knows, okay, he understands.
All right.
So the question, Mr. Davis, is, and I've not seen the pre-sentence report, Your Honor, but Mr. Davis, do you want to go ahead with sentencing with Judge Bryant? Do you want to respectfully ask to withdraw your plea, have the felony charge reinstated, then back to the drawing board? That's, we've talked about it. You got to make a big decision.
Okay, Miss Bryant, Miss Judge Bryant.
Mm-hmm.
With all due respect, I apologize for being rude. I just felt like I was getting shambled by my former attorney, because what he took me out in the hallway and talked to the prosecutor about, yes, you're right, it wasn't put on record. But they clearly took me out in the hallway and say, take this plea and just pay this money, and I'm not going to look forward to moving forward and pressing any charges. And then go downstairs, pay the $1,200, and then everything will go away. And then so when the judge got to talking and then it got shifted, that's when I got upset. I wouldn't get upset about nothing else. I mean, I was mad.
Seemed to me like that would have been an appropriate time to ask Judge King to withdraw the plea. Seemed to me like that's why you say, has anyone promised you anything that was not placed on the record in order to get you to make the plea? But your anger was misplaced, and it was misdirected, and it was rude, and it was disrespectful.
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic. I wish I tried.
Okay.
And having read the transcript, I don't believe that the option of withdrawing the plea is an option. Judge King was clear. Judge King was clear, unequivocally. He said, I can only tell you what I would do.
Okay, and then also, Judge, I want like they sent the papers in the transcript that they sent the papers downstairs for me to go pay, and also Mrs. Smith filed a motion like a week
Couldn't
later.
have sent no papers downstairs for you to pay because Judge King cannot impose any sentence. So there was no sentencing. There was no sentencing. Let's be clear. There was no sentencing.
I understand that, but it's in the transcript saying that we are sending the papers downstairs for me to go pay. I stayed downstairs for an hour and the papers never came. I was at the window.
Well, there is some language, Your Honor, in the transcript regarding some paperwork going down to the probation department. But
probation, a referral to probation for a pre-sentence investigation.
I agree with that. That's what I believe.
Okay.
So I don't think there's any language in the transcript that talks about the agreement. I'm just trying to see here whether there's standard statements that are made before a plea is taken regarding promises and things like that. And it says, do you understand the rights? And you had an opportunity to talk to your attorney, and then you're waiving your rights. That was the standard thing. Anything regarding a promise of the sentencing, but let's see here. You're giving up your rights. You have a right to be presumed innocent. He goes through the standard subpoena powers. So I don't think there's any language in that transcript regarding whether any promises were made. Though when they got to the last paragraph on the last page of the transcript, Judge King specifically says, this is what I would do, but I'm not Judge Bryant, and she's got to make her own decision. And never was given an opportunity after that statement. It just went right to, okay, you're sentenced. You'll get your sentencing date and be on your way. So there's some frustration on his part, justified or unjustified, as to the procedure of what happened. But that's kind of where we're at, Your Honor.
Well, my decision is that I'm not going to allow the withdrawing of the plea.
Then, Your Honor, I haven't had a chance to see the probation report, but so I don't know what the recommendation is. I don't know if you want to give the people a chance to send that to me, whether you can give me the highlights over the phone so I can elocute on his behalf. But I did not get an email or anything in the mail regarding a proposed pre-sentence report. Now, maybe it was given to Mr. Smith, but I have filed an appearance in this case.
It probably was. The pre-sentence investigation is dated April the 12th, 2023. So it is the original pre-sentence report. We can send it to you and I can adjourn the sentencing, give you opportunity to go over it with your client. It's a standard recommendation. In fact, it's a little surprising to me of the recommendation for 12 months probation, since Mr. Davis has a previous conviction for aggravated assault. But nonetheless, well, I guess that's not a conviction. It's not.
Yes, Judge, is that probation reporting or non-reporting?
Oh, all of my probations are usually reporting, depending on what I order. There is a recommendation for anger management. And because of the way that Mr. Davis always acts when he comes to my courtroom, he definitely needs anger management. So there is a recommendation for anger management.
I hope he's presenting himself professionally this morning, Your Honor. He hasn't raised his voice. He hasn't seemed too frustrated. I think I
fashion myself a body language expert. That's a part of what I'm gonna do when I leave the bench. And every time I say something that he don't like, I'm from the east side too, 6115 Seneca. Every time I say something he don't like, he rolls his eyes, he grunts, his nose inflects out, his mouth. I'm gonna make money helping people pick juries because I'm gonna watch the body language of the jurors. I fashion myself to be very insightful in that area. So no, he has not yelled and raised his voice today. No, he has not exhibited the behavior that he exhibited. But it is clear to me that for whatever reason, whatever occurred between Mr. Davis and Mr. Smith, number one, he's not over it. But had he gone into the courtroom with Judge King and actually paid attention to what the judge was saying, we probably wouldn't have all this anger and stuff right now. But there is a recommendation for anger management. Now, there was a recommendation in my previous case for anger management. And then I said, well, I'm going to focus more on this area. So, Madam Prosecutor, is there any objection to me reducing that anger management? And then she said, no objection. Because that's the kind of judge I am. I'm a judge who believes in an individualized sentencing, right? I'm a judge that believes in looking at the circumstances and deciding the sentencing. But from what I see from your client, that recommendation for 12 weeks of anger management, it almost should be 24 weeks. That's what I see. But I probably wouldn't do that, but that's what I see.
So, Mr. Davis, you've kind of got an idea of what there's obviously there appears to be no recommendation of incarceration. Looks like 12 months reporting probation. There's going to be some weeks of possibly of anger management. Do you want to go into a breakout room? Or are you ready to proceed to sentencing? Because you're going to the recommendation is not going to change, whether we delay it or not. And I think
it don't matter. I mean, Judge, listen, I didn't want you to take nothing the wrong way, this, that, and the other, but
No, these comments are not, these comments.
I have been through so much. I'm from the east side of 6 Mile Grass here.
Sir, can you hear me? Am I muted? Am I muted?
Oh, let me see.
No, I'm not muted. So at this point, I only want to know, are we proceeding with the sentencing today? And if we are, then Mr. Davis will get an opportunity to speak. But right now,
I didn't know that.
No. Is, are we proceeding today? Because I've been through a lot too. Yesterday was the anniversary of my sister's death, who died young after she suffered a stroke. I've been through a lot too.
Yeah.
They thought I had breast cancer. I've been through a lot too.
Right.
I was homeless. I've been through a lot too. We all been through a lot.
Yeah.
We don't come in here and take out our frustrations on the people who've done nothing to you. No, that's not how it works. Now, I've been real patient. So, counsel, I'm gonna send you and your client to a breakout room, and he could tell you if he wants you to go over the report in detail. I will give you an adjournment if you request it, because we did send it to Mr. Smith, and I'm sure Mr. Smith, perhaps he didn't forward it to you. So let's send you both to breakout room number 3.
I think Mr. Davis can answer that question.
Oh, okay. Well, because let me tell you another observation. Remember, I said I was observing, and this is what and so there's a judge sitting in my office because she's going to help with my docket next week. So she had come in to just kind of watch and then so I go over the docket with her. She just came in after we started, and she got the same feeling about Mr. Davis that I have. She said she's from the east side too. She recognized all that aggression too. It's a lot of aggression going on with Mr. Davis. And so maybe he might want to wait. But I know how to separate. So are we going to sentencing today, or am I getting an adjournment?
Mike, do you want to go ahead right now, or you want to get an adjournment?
No, please, let's adjourn it.
Okay.
No, so yeah. Yeah. Can we adjourn it, please?
We're going to adjourn to
If you're happy and you know it, clap your hands.
Counsel, is 23rd a good day for you?
It is a good day. All I have is a 10:30 in probate court. But
wait, I apologize. Not the 23rd. Excuse me. No, I can't do the 23rd. The 25th, the Friday.
That's fine.
Okay, I can adjourn it to the 25th of August.
What time, Your Honor?
9 o'clock.
And what would be the procedure, if any, Your Honor, for me to get that report? Should I come down to the courthouse to physically?
Oh, no, you don't have to do that. If you could, put your email in the chat, or if you could just call the courtroom, Mr. Flanagan will email you the report.
Great, I'll call the courtroom.
Okay, do you have the phone number?
I don't. If you could give that to me, I'm ready.
Okay, 965-2295.
Terrific. I'll do that as soon as.
Yeah, he'll email you the report. You don't have to come down to get it.
We'll see you on the 25th at 9 o'clock.
Okay, then everybody have a great.
Yes, Your Honor.
All right, this is case number 115716101. The People versus Janine Thomas Orr. Defendant is charged with operating while intoxicated, and today is the day set for review. Ms. Stevenson?
Rakedia Hall on behalf of Janine Thomas Orr. Ma'am, may you state your full name for the record?
Janine Denise Thomas Orr.
So I just received an update a short little time ago, but the reason I say that it doesn't look like she should be on my docket, but let me just see. Okay, so see, this is why I don't like this whole thing right here up at the top. This is I don't know. I guess I've never paid attention to that. Miss Thomas Orr used to be in one of the specialty courts. So let me see. Oh wait, I think I remember. Why does that sound familiar to me? When was that? Okay, maybe. All right, and then so let me just see. Oh, this might have been the one that was returned to me.
That's correct, Your Honor.
Oh yeah. Okay, she should be here. She was returned to me from the specialty court. Oh yeah. Okay. I'm going to adjourn the case. We're going to come in person. Yeah, we're gonna come in person. We're all going to come in person. Yeah. Because Miss Thomas Orr doesn't want to do this. Child, she don't want to do this. Well, let me see. What was the last thing I did on here?
Your Honor, I'm not sure if you recall that Ms. Orr, Thomas Orr, was sentenced to 45 days in Wayne County Jail, I believe by this court. And today was the date to get her resentenced and back on track for.
Did she do the 45 days?
I believe that she did about 10 days, and then
that doesn't comply with the court's order. That doesn't comply with the court's order. You know, I try to tell my people, when the jail try to set you free, tell them don't. If I said 45 days, that's what I meant. That's what I meant. If I said 45 days, I didn't mean 10. I meant 45. So unless the jail is going to tell me and why they let her out in 10 days instead of 45 days, she going back for 35 more days. She couldn't have possibly earned good time credit in 10 days.
Your Honor, it's my understanding that you actually allowed her to be released early.
Oh, I did.
What if I told you this dish was actually healthy? Let's be real. Factor's menu is way healthier than the competition. Their chef.
Prove it to me. What'd I do? I brought her back in and said she could go.
That's my understanding.
Let me see. Mr. Flanagan, I don't have my because you see me fussing at the jail. She was getting ready to go back for 35 days. Hold on. Let me see. Let me see if I should be fussing at myself. Hold on.
Should be fussing at us for arguing so strong for Miss Thomas or.
Hey, no, I'm never gonna fuss at you all for doing that. So I said, okay, I was gonna set the 45 days. All right. And then I said no credit for prior time served. No, I said no early release, no work release. I said that. Okay, then you are not being honest. See how y'all, I mean, I shouldn't say that. You going by what you thought. But hold on. Okay, so on October, no, that doesn't make sense right there. October 3rd. Oh, yeah. October 3rd, she came before me. I gave her the 35 days. Then I said all of that stuff I said. And then she came back. Oh, October 13th. Oh, yeah, I probably did it. I did it. All right. So October 13th, she came back to me on review. And then let's see what I did. Okay, then I held it in abeyance. But can y'all go in there and correct that? I'm such a stickler for stuff, but right under October 13th, when it's supposed to say held in abeyance, just correct that sentence. Take out the A. And then, okay, so I held it in abeyance the 35 days. I reinstated her probation. And then now she's here. So now let me address this. So now let me tell you why this is still not good. So that was back in October. It's January. Mr. Sciotti said he ain't seen her.
So, Your Honor, she has been contacting the probation department, and they keep telling her that she's not sentenced yet. In the register of action that I have, it says that she's supposed to be resentenced. And she came in November when you were on leave, and Judge Baltimore just adjourned it to now so that you could handle this situation for her to be resentenced.
I don't even know what that. So let me tell y'all. First of all, I'm not. I indicated, and I guess I have to get the thing or whatever. Hold on. So I'm looking at October the 13th, and I said, I was going to set the terms November 15th. So let's be clear, it was no resentencing. So I don't even know what that means. I don't know why somebody's saying resentencing, but I reinstated her probation. That's the sentence. And then the terms were going to be set on November 15th. And then I wasn't here, and Judge Baltimore said he wasn't setting no terms, but instead of having her come back in December, he came back all the way in January. That doesn't make sense. Okay. So nonetheless, because she's been doing nothing for 2 months.
So actually, she has been doing things. It's just that she hasn't had the terms yet to know what the court was expecting. She's working, and at Universal Coding, she sees a substance abuse counselor and doing drug and alcohol drugs with a substance abuse counselor. Other than that, she's not aware of any terms set by the court, and she has been contacting the probation department, but they keep telling her that she hasn't been sentenced, and maybe it's because she
don't use the word keep. Don't use the word keep. Don't use the word keep, because let me tell you, if they told her that one time, she ain't called back. They didn't keep telling her nothing. She didn't call back. She called them. If she called them one time, she called them, and then she didn't call them back. So they told her one time that there were no terms set, and then she said, okay. So let's set the terms and conditions of probation. Let me pull up. And
Your Honor, just for clarification, on the register of actions for the last date that I can see is September 25th, where she was scheduled for sentencing for October 3rd. But at the bottom of that date, it says that the defendant was terminated from drug treatment court per Judge Holmes, sent back to original judge to be resentenced. That's where the term for the resentencing comes
And
from.
I already resentenced her. What I'm saying is, and then I resentenced her. So you got to go past that date. I resentenced her to 45 days in the Wayne County Jail. 10 days she served, 35 days held in abeyance, and then why is this not coming out? So I resentenced her, and then I said the other terms would be set at that review date. And so she was sentenced. Nobody's out there not sentenced. And then I don't know why Judge Holmes' clerk would put in resentence. I don't know why they would do that, but I can't go by that, what they put in the register of action. I can't go by that. I keep telling everybody, including probation, the register of action doesn't, what's that? That's nothing. That's some information that the clerks put in. They could put in whatever they want to put in. So if the clerk had put in 1,000 days in the Wayne County Jail, everybody would say, oh, the judge sentenced her to 1,000 days in the Wayne County Jail. Of course not. That would have been a mistake on the clerk's part. So I don't go by what the clerk puts in the register of action, because the register of action is just a guide. It's just something that go by. If anybody want to know what I did or said, that comes through the court reporter. That comes through the official record of the court reporter. But nonetheless, with respect to the additional conditions of probation, where she was only on for 6 months, that's why I don't understand why the date would have been given so far down the line if it was waiting for me, wanting to wait for me to impose the additional conditions. Why would we then let 3 months of the 6-month probation go away? That doesn't make sense.
With Liberty Mutual, you can customize your car insurance to save hundreds. Could you look away?
But ma'am, stop shaking your head and stuff, because you wouldn't even be here if you had complied with Judge Holmes. So don't act like nobody inconveniencing you, because we're not. You have inconvenienced us. You have dragged your feet as slow as somebody can drag their feet. You have moved at slower than a snail's pace. So all of that co-signing with me about what I'm saying, you can stop. Because this is your fault that we're here. It's your fault that you got to the place where I was gone for 30 days. That's your fault. It's nobody else's fault. It's yours. So you appear to be so quick to blame somebody else and co-sign it with somebody else. And oh yeah, the judge shouldn't have did that. No, you shouldn't have done it. You should have done what you were supposed to do. So as I was saying, I had only extended the probation for 6 months. At the time, that was in October. So we're already 3 months in. Now, what I'm going to do is I'm not going to extend it at this time past that 6-month date, because here's the thing. There's zero. Can I do a zero? Because I want y'all to zero. There's no space. And Ms. Thomas Orr is really distracting me every time she put her ear up to this thing. So, I mean, one thing about it, we know that when we come to court, we have to be able to hear. Why wouldn't you get some headphones if you can't hear? It's not the first time we're doing this. Okay, so I'm not going to move it past the 6 months, because let me tell you this. She has this 3 months and the rubber has met the road. right? I'm not accepting any excuse. I don't care where she lived. I don't care if the bus don't come from Flint. I don't care if the bus, I just don't care about whatever excuse she's going to try to give me. Okay. And if she fails to comply with the terms and conditions in this 3 months, she's going to serve the 35 plus whatever else will add up to the 93. And then we're going to just close it out, because this is ridiculous. And people are trying to help you, but you don't want to be helped. And so when a person don't want to be helped, then they're just not going to be helped. And they're just going to go on, serve this little time, and keep on going through life, addicted. It's only so much we could do on a misdemeanor docket. So I'm not going to extend a lot of time and energy into something that Judge Holmes spent months trying to get Ms. Thomas Orr to comply with. Now, all of a sudden, you're coming in here making it seem like she just knocking it out the ballpark. Well, she didn't even knock it to in front of the plate in drug treatment court. She kept on missing the ball completely. So let's see what she's gonna do in 3 months. But yeah, I don't have any really confidence that it's going to be done. So we're going to continue it. The final review is going to be April. So we're going to do April. April the 19th at 10:02. April the 19th at 10:02. That's in person. It's in person. It's in person. If that means that you got to leave your house at 7 o'clock in the morning, at 6 o'clock in the morning to get down to Detroit by 10:02, then let's leave our house at 6 o'clock in the morning, so we can get to Detroit by 10:02. Mr. Flanagan, did she pay any money when she was in front of Judge Holmes? Let me see. Back up here. So it looks like she still owes $1,220. At least that's what the register reflects. So we're going to reinstate the $1,220.
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic. I wish I tried.
And previously, she was ordered, I'm gonna go back up here and see her previous order from Judge Archer in 2018, before I sentenced her to drug treatment court. She was going to, she was on a 12-month probation. She was going to attend the Victims Impact Panel. So we're simply reinstating the previous probation terms. She was going to attend the Victims Impact Panel. I don't know what that means, 1 time per week. The Victims Impact Panel doesn't work like that. She's going to attend a 12-step program once a week. She's going to complete the Alcohol Highway Safety Education Level 1. And of course, she shall not use or possess any illegal substance, no marijuana without a valid medical marijuana card, no opiates without a valid prescription, outpatient treatment. She will continue in her outpatient treatment, random urinalysis twice a month. She shall not, of course, consume any alcohol in any form, pay any outstanding tickets, clear up any warrants, At the time, there was this dangerous driver simulator, but I don't believe they have that anymore. She's of course going to view the consequences video. And I suppose they have assigned Officer Schiatti to the case. So that's her probation officer. Hear me when I say, unless we run into an apocalypse, she need to do this stuff. Hear me when I say she doesn't have any room for any excuses. Hear me when I say I'm not scheduling any review before this April 19th date. She's better get in touch with Mr. Schiatti and get to moving on this stuff. And then, of course, the 35 days is still held in abeyance. And then 93 minus 45, if she fails to do the probation, she's going to do the 45. Or I should say she's going to do the 35 plus 48. So she's going to do the 83. She's going to do 83 days if she fails to complete this. Hear me when I say April 19th is in person. Anything further, Ms. Hall?
Yes, Your Honor. I do understand that she owes $1,220 since she did serve the 10 days in the Wayne County Jail.
Oh, no, 10 days was penalty. 10 days was strictly penalty. It's not credit for nothing. The 10 days was penalty. She got kicked out of drug court in stage 1 after 14 months. She got kicked out of drug court, still in stage 1. There are 5 stages. She was in stage 1 after 14 months. The 10 days was strictly a penalty. So the answer is no. Now she can get some community service, but she's not getting credit for nothing. That's penalty.
Right. Ms. Thomas, or would you be able to pay the $1,220, or would you prefer to have some of that amount converted to community service?
Well, from my understanding, I had a different price. They dropped it when I was in sobriety court to about 800 or something.
Ma'am,
So
it's not
does it
dropped.
change?
You did nothing. You did. Oh my goodness. You did
No,
nothing.
I'm asking, did it change?
Okay.
I would rather just pay the money.
Okay, Your Honor.
Pay the money. She's gonna pay the money because that question right there just it sent my little rocket to the moon. So let me come back from the moon. Of course, nothing that Judge Holmes said. Of course, I care about nothing that happened in drug court where she failed. And this right here, me looking in her ear, down her eardrum, is completely inappropriate for court. So we're going to end the hearing because she clearly can't hear us. And then you all can talk with her because I'm not going to keep looking down her eardrum.
Yes, Your Honor.
If she wants to do community service, you could bring that to Mr. Schiatti's attention.
Okay, thank you.
All right, we're all set. Have a great day. Stay safe. Let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the
And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, man.
In 56 years, I know what laughing looks like.
I wasn't laughing, man. Why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between Miss Wilson, you got that camera real up close to you, but if you're not properly attired for court, you need to put on a jacket too. All right, I'm gonna put you in the waiting room. Your lawyer is not present yet. But while you're in the waiting room, please put on a jacket or change your top. This is, your lawyer is Mr. Wordbling. Okay, so I'm gonna put you back in the waiting room, Miss Wilson. Ms. Davis, I'm going to put you in the breakout room, and a lawyer will be in to speak with you shortly, okay?
Okay, Your Honor.
Please remain in the breakout room until the lawyer comes in to talk with you.
Okay, and then I'm gonna put the...
No, you can put the jacket on while you're waiting for them to come in.
Okay, this is a dress. It's a dress.
Oh, okay.
Yeah, okay.
Oh, okay. All right, well, I'm ready on Ms. Davis, who wanted to say whatever she was saying. So let me assist Ms. Davis. So Ms. Davis, let's not ever do that again. Let's never do that again. Ma'am, let's not ever do that again, including right now. So here's the first thing. We are going to only unmute when asked to do so by the court. Number two, the baby can't come to court. The baby can't come to court. Baby can't come to court. Number three, don't log in laying down, whether it's on a couch, in a chair, or whatever. So let me be clear. We're in court, and we're going to present as though we are in court. Otherwise, you have to physically come to court. So if we can't sit up straight, as if we're standing up straight at that podium, then you can't attend court on Zoom. Then you have to come and stand at the podium. So
Yes,
let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the building. I'm at 36th District Court. The building is open for all defendants who have matters pending before the court. So you're going to talk to me like I am the judge presiding, not like some person that you just met on the street or whomever. I don't know. But I'm giving you the instructions for how to attend court. They are the instructions for everyone who comes here. If you don't want to follow them, I don't know what to tell you. Now, I'm sure that in the beginning I said, I need everyone to remain seated, stationary, in an upright position, and ready to attend court. This is case number 164609001. The people of the state of Michigan versus Crystal Davis. The defendant is charged with one count of malicious destruction of a building, 1 count of assault or assault and battery. And today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Crystal Davis. Ms. Davis, ma'am, please unmute and tell the judge your full name.
Good morning, Your Honor. Crystal Davis.
Today is the date set for a final pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. Davis, Your Honor, I'm not certain whether the complainant was required to be present today. If that is the case, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter? You're muted, Ms. Ritter.
Sorry, Judge. My note says that there was an arraignment on the bench warrant on May 1st of this year, and a final pretrial conference was set for today, but I don't have any notes that the court required the complainant witness to be present, so I will defer to the court.
Not if it was an arraignment on the bench warrant, I didn't.
Okay.
I mean, again, I don't have my notes, but that would generally I would not have.
Okay.
And it's at 9:04. That means that your client has failed to appear probably more than once, and then I set it for 9:04, which would have meant a high bond if she didn't appear today.
Okay. So, Judge, could we set up? I know it's a 2016 case. I don't know. I know that there were some efforts at an alternative dispute resolution when the case initially came about. We have an indication that that alternative dispute resolution has been complied with, and it was back in 2017, but Ms. Davis did not provide proof of that to the court. Could we have the matter reset for final pretrial conference to determine whether or not actually requiring the complainant's presence, and if the complainant is present, giving us an opportunity to still do the alternative dispute resolution?
So in 2017, that would have been under Giles or King. No,
yes,
it could have been under Archer. Who I don't know who was the judge back then.
I thought it was King.
That seems like it wasn't King.
But it may have been Judge Archer. I don't have the ROA in front of me right now.
Did she used to do alternative dispute?
Yes, Your Honor. The register actions did reflect that should anger management be completed, that there would be a dismissal. And
the anger management might not have worked. Because she's acting angry today.
So I have the certificate from 2017, but again.
Okay. I mean, I'll honor it, but I'm telling you, she acting angry today. So if Miss Ritter can look at her notes or whatever, and I mean, if that was the agreement back then, I suppose we'll honor it today, but okay, all I can say is I'll honor it today, but she might need to go to Mr. Rice's class. Is that certificate from Mr. Rice?
It's not, Your Honor.
I know it's not, because if it was, she probably wouldn't have been acting like this today. Okay, Miss Ritter, I want you to look at your notes. Ms. Stevenson says she has a copy of the certificate. The register reflects, that they were engaged in this alternative dispute resolution, and then she had a case dismissed. So if that's what the register reflects, or if that's what the notes reflect, maybe I also need to look at the actual file in the courtroom. Actually, Ms. Rutter, do you have the handwritten ROA where the judge writes on the file?
Give me one moment, let me check, Your Honor.
Yeah, check and see if you have that. Let me see what the judge wrote. if the judge wrote something, that's when we were definitely writing in the files back then. And then Ms. Ritter, you can also try to contact your witness. So I will adjourn the final pretrial conference. But if that was the agreement, like I said, I will honor it if she does have that proof. Let's set a final pretrial conference for that trial is really going off my docket. Let's do August 21st for the final pretrial at 9:04. And let's let me write this down. Proof of anger management and confirmation of agreement. Okay. So that's what I need that day. And I know we could, I was trying to see if I could do it sooner, but every day says no more, no more, no more. So I'm all booked up.
Okay.
All right. Well, unless we do it on one of those. I don't even see where we're doing any afternoons. No, because of that trial. Yeah, I'm booked up because of that trial. So that's it. Anything further then with respect to this?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Davis. Thank you, Your Honor.
All right, then we're all set, Ms. Davis, until August 21st at 9:04. Have a great day. Stay safe. You're welcome.
Thank you, Your Honor.
You're welcome.
Your Honor.
He didn't. Mr. Hardwick, state your name.
Kevin Lamont Hardwick Jr.
All right. Today is the date Mr. Hardwick has been brought before the people. Before the court on a tether violation. It says that he was found to be outside of his curfew as well as to have a low battery on the tether. Additionally, there's some information that indicates to the court that Mr. Hardwick is without a home, has some mental health issues, and maybe on drugs. Court is inclined, based upon the report from the tether unit, to tether Mr. Hardwick to a drug rehab facility. Is there anything on behalf of the people or Mr. Hardwick with respect to the court's intention?
Nothing on behalf of the people, Judge.
No objection on behalf of Mr. Hardwick, Your Honor.
All right, then the court is going to tether Mr. Hardwick. The tether conditions remain. The only thing that's going to change is the location of his tether. He is not going to be tethered to the place that he was tethered to. And Mr. Hardwick can only be released to a rehab facility. And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? Hold on, it won't let you. Hold on. What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, man.
In 56 years, I know what laughing looks like.
I wasn't laughing, why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between laughing and wiping your face.
I wasn't laughing, man.
Yeah, okay. I didn't get all the way this far to not know the difference between laughing and wiping your face.
Wasn't laughing, man.
Okay.
I be having seizures.
Yeah, okay. Well, you wasn't having a seizure just now.
I know. I wasn't.
Yeah,
laughing.
I know. So then it wasn't no reason to bring up seizures. Nobody's on here having seizures right now. Court is going to tether Mr. Hardwick to where was the place when I was, there was an issue with Judge Cobb's order, and they were saying they don't take women. I mean, they didn't take women, and Judge Cobb was trying to tether the person to Team Wellness, Team Jefferson. It was Team Wellness. So I'm going to tether Mr. Hardwick to Team Wellness. As a condition of his bond. When is his next court date? Ms. Rudder?
August 21st at 8:30.
All right. And then he'll be back before me for retrial August the 21st. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Hardwick. Thank you, Your Honor.
All right, Mr. Hardwick, you're all set. They're gonna get you a tether and get you a bed at Team Wellness.
Thank you, ma'am.
You're welcome. Have a great day. Stay safe.
You too.
Thank you.
Yes, ma'am.
Start your video, Mr. Morris.
Okay.
Mr. Morris, take the do-rag off your head. And then I'm gonna say, and your braids all together. Why you got on? Y'all just be coming on do-rags for no reason.
No, because I was, yeah.
Because aren't you trying to look good for a live Zoom as opposed? What you saving the hairstyle for? Don't answer. Just say, yeah, okay. Go to the breakout room, Mr. Morris. Go to the breakout room. Breakout room number 2. All right, I'm ready on Morris, and then Patterson. Mr. Morris, turn your camera back on. All right, Morris and then Patterson. And Ms. Stevenson, you all are confused me with that HIDA designation, but I'll get to it in a minute. This is case number. This is the second person y'all letting come to court with a t-shirt on. Students are going to have to tell them to change their clothes. This is case number here it is. Case number 145509101. The people of the state of Michigan versus Davon Lawrence Morris. Defendant is charged with 1 count of driving while license suspended, revoked, denied. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of
Ronnie Melka appearing on the behalf of the defendant, Devon Morris, who consents to my appearance. Is that correct, Mr. Morris?
Yes, ma'am.
Can you please state your name for the record?
Davon Morris, Deontay Morris.
What does that mean? What does that mean? He said Davon Morris, Deontay Morris. What does that mean?
No, I said Davon Lawrence, Deontay Morris.
Oh, okay. Thank you. Because I'm saying you had 2 names. Okay, so your name is Davon Lawrence Deontay Morris.
Yes, ma'am.
Okay, thank you. Today is the day set for an arraignment on a bench warrant. What did Mr. Morris capious from, please?
Mr. Morris capious on May 12th, 2017.
From?
From missing a court date.
Counsel. No. Question is, what did he capious from? I know he capious from a court date. Was it a pretrial? Was it an arraignment?
Oh, it was a
final
pretrial.
Okay. Well, we'll continue. Now, here's the thing. Mr. Morris, in 2017, I think I was doing, I don't know what docket I was on in 2017. I don't know. I know I wasn't on this one. Now, let me tell you something about these misdemeanors for my docket. Setting up a meeting with the chief of police. I'm asking the chief of police for a warrant fugitive arrest team for the misdemeanor docket. We're not going to wait for you for how many years that's been. We're not gonna wait for you this time. You need to come to court, okay?
Okay.
So I don't want to keep doing these old cases, okay? Because people get new cases. My docket is too full, and then the people come on here fussing at me because I can't give them a court date in 2 weeks and 3 weeks. Okay, so I'm gonna give you this court date. I want you to show up and write down the right date.
Okay.
Okay. When is your court date?
August 24th at 8:35
Okay.
a.m.
All right, Mr. Morris. He like, I got it, Judge. And then don't come on here with that do-rag on, cause which one you think look better, the do-rag or your hair?
My hair. I'm sorry.
Oh, exactly. Okay. All right. Anything further with respect to Mr. Morris?
Nothing further.
Miss Ritter?
I'm sorry, Judge, nothing from the people.
Okay. Miss, I'm here by myself all the time.
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our end.
On behalf of Ms. Meriwether, Your Honor, we've had the opportunity to review the pre-sentence investigation report, and we do offer the following correction. Well, actually, Your Honor, at this time, we have no additions, corrections, or deletions, and Ms. Meriwether does stand ready for sentencing.
With respect to sentencing, anything on behalf of the people?
So, Your Honor, there was a plea agreement for a recommendation of a term of probation, 24 weeks of anger management, no contact with the complaining witness, Ms. Betty Griffin, and restitution for any medical out-of-pocket expenses that Ms. Griffin may have incurred in result of this incident. And on page 4, there is a victim statement from Ms. Griffin. And she is in person today, Judge, so I would just defer to Ms. Griffin if she would like to make a victim impact statement orally to the court. However, I don't see any restitution information, and I'm looking through my notes, Judge, and we didn't receive any restitution information, so I would defer to Ms. Griffin if there is any medical expenses that she has that could be tendered to the people so that we could see if it qualifies for any restitution. And at this time, Judge, I would turn it over to Ms. Griffin if she would like to make her victim impact statement to the court at this time.
Ms. Griffin, did you want to make a statement to the court?
Yes, Your Honor.
Come up to the podium, please. Ms. Griffin? Ms. Griffin, also, I'm in the building. Did you want me to come downstairs so that you could talk to me in person, or are you okay looking at the screen? I am in the building.
I'm okay looking at the screen, Judge.
Okay. All right. Go ahead, Ms. Griffin.
Your Honor, on that day, I was physically and psychological and emotional stressed. I had to stay away from my home for 2 months because I was fearful to stay in my home. I asked the court to send to jail her and her sister the full extent of the court. Thank you.
All right. Thank you. Anything further on behalf of the people?
Nothing further at this time, Your Honor. Thank you.
All right. Miss. I'm sorry. Miss Griffin, you can actually have a seat. You can go back and have a seat on the front row. Thank you. Okay. On behalf of the defense.
Thank you, Your Honor. So in the police description of the offense, the information contained there is consistent with that which is in the police report in terms of the location to which the police responded. But the police responded, actually, according to my client, they didn't go to 5978, the street name that's mentioned in that report. They went to 5960. And that's important because my client wants the court to know that she and her co-defendant are the parties that actually called the police out to the location. So unfortunately, there has been some acrimony between these neighbors. There have been prior police reports, Your Honor, and there have been prior allegations of property damage by the complaining witness. Those complaints have been made to the police, Your Honor. And on the date in question, I think that the report indicated that this all stemmed from, this particular incident stemmed from the complainant allowing her pets to enter upon the property of the defendants. And my client's position is that that is absolutely incorrect, that the complainant actually had two animals at least tied to the defendant's fence. And those animals were in distress. Is it the defendant's fence, or is it the yes? Is it the common fence between the two properties? It's on the property of the defendant, so it's the defendant's fence. Is it? Is that what the law says? But let's go ahead. Okay, so which is what caused my client, and I can't speak to the co-defendant, they have a different sentencing date coming up, which was what caused my client to go outside and come into contact with the complaining witness in the first place. So I am well versed in the law of self-defense and all that. And so having conferred with Ms. Meriwether, she having had the opportunity to get an understanding of what self-defense is and what self-defense is not. She did offer the court a plea of guilty and accepts responsibility for her actions, but we don't want the court left with the impression that that my client, left their house and took a broom to this person who is over 20 years older than her. That's not the way the incident happened. Well, Ms. Stevenson, is your client, if your client is not going to address me, I don't know, but maybe you should, because this is the first time that I've ever requested the full police investigator's report so that I can try to figure out what's going on and why an individual who is 20 years younger than a person would take.
These glasses destroyed a multi-billion-dollar industry. Nobody believed me at first, but now everybody wants a pair. My friends roasted me for buying miracle glasses.
Take a broom to their head. So at this point, somebody better tell me some more information or it's not going to be looking so good. May I speak? Not yet. No, ma'am. Ms. Stevenson? As we anticipated, Your Honor. So that is the exact reason I'm getting a little bit more involved in the incident itself than I normally would at sentencing. So my client, the complaining witness and the co-defendant, who's not yet been sentenced, were engaged in a physical altercation. And quite frankly, Your Honor, I think it's in the police report. That altercation started by the co-defendant spraying water on the complaining witness, which is what causes. So my client goes outside to try to come to the aid of her sister when a fight ensues between the complainant and the co-defendant. And because the co-defendant is actually the person who started that altercation, we believe that a self-defense claim or a defense of others claim would fail. And I'm so sorry, Ms. Stevenson, I hate to interrupt. I do apologize to the court, but Judge, I would just object to Ms. Stevenson getting into the facts involving the co-defendant, because actually I don't even think that co-defendant has been set for sentencing. I don't think they took a plea. What? But that don't have nothing to do with this.
Okay.
It's
Okay.
So for those reasons and some others, we decided that the best, the most lawful option would be to go ahead and offer the court a plea of guilty. But Ms. Meriwether did not leave her home. She didn't come outside of the house even to aid her sister armed with a weapon. It is her position that at the time of the incident, during another altercation, that the complaining witness lunged at her, and that's when Ms. Meriwether struck the broom. Is that okay? Absolutely not. It isn't. And that's why Ms. Meriwether did offer the court a plea of guilty. But we don't want she indicates that Ms. Meriwether indicates that after she struck the complaining witness, that the complaining witness actually did come at her. The two of them did engage in a physical altercation, where Ms. Meriwether was on the ground. Ms. Meriwether denies, any biting or anything like that. So there is volatility between these parties. Ms. Meriwether's response was inappropriate. She is here to take responsibility for her actions. We're not going to object to, actually, it was the plea agreement, an extended period of anger management. I did want to just point out that in the pre-sentence investigation report, I think in the evaluation section, it indicated that Ms. Meriwether appeared to show a lack of remorse. And I wanted to get under that in preparing for sentencing today. And her expression to me was that she is very remorseful. She'll explain that to the court. But her affect may be dulled a little bit by the fact that this has just been an ongoing problem with this neighbor, that it's just been so much back and forth. And she is very, very, very frustrated with the situation. And for that, the longer anger management course probably is in order. So we just don't want the court left with the impression that my client kind of leaves out of the house and starts swinging at this woman with a broom and goes upside her head or anything like that, because the facts just are more complicated than that. The end result, which is why we chose to offer the court a plea of guilty rather than proceeding to trial, is that Ms. Meriwether should not have, she misjudged the situation in moving out. She believed initially to aid her sister, that had she known that things were not the way she perceived them, she may have engaged in a different course of action. And she has expressed remorse to me. I hope she will do that to the court this morning about the entire situation, about placing herself in the position that she's in right now. And she's ready to make amends, Your Honor.
Okay, before I move to your client, didn't we, Ms. Rivers looks like I saw, did you all speak to Ms. Rivers?
I had a plus sign initially before Ms. Rivers. She left and came back, but I recently got some information that I want to share with her, which is why I didn't put the plus sign on back in front of her name, Judge.
All right. Those who I've just let in the courtroom, please accept to join the breakout room and wait for the lawyers to come in to speak with you. Do not leave the breakout room until you have spoken with a lawyer, and please do not request my assistance in the breakout room. Wait in the breakout room until the lawyers come in to speak with you.
If you live in an Alabama zip code and have 0 DUIs in the last 5 years, listen carefully. I was an insurance agent for 30 years, and what I'm about to tell you could save you up to 80% on your auto insurance. Here's what the industry doesn't want you to know. Alabama drivers pay the most for car insurance out of any state in the country. As we all know from the recent 2025 leak, insurance companies are now in trouble for overcharging Alabama drivers by as much as 80% for the same coverage. We call drivers in this state gold tier clients, the ones we'd fight to keep because of inflated commission. But here's the dirty secret. If you're in Alabama, they won't let you know you can lower your rate now, and they're happy to keep overcharging you. My neighbor Jessica from
All right. All right, would Ms. Merriweather like to address the court?
Yes. I regret my actions. It was totally out of character of me. I've never been in any trouble. I've never been in any fights. It's just a situation that got out of hand. I'm not a violent person. I have never been arrested. This is my first time being in a fight, being in an altercation with anyone. And I'm just, this whole situation is just, it saddens me. It just saddens me because I've never been in trouble before. I've never been arrested before. I've fought 41 years of my life. I've never been arrested. Never had any issues with anyone. It just the situation just got out of hand. And it wasn't, am I muted? No.
No, you're talking.
Yeah, this situation, it was just a sad situation because we've been neighbors with her. We've had troubles with her in prior years. We had trouble with her that summer. She had torn down our fence on the left side of our property, and we called the police for that. That's what led up to the whole situation. The whole situation with the incident is she tore down the fence on the left side of our property. So it was a wire iron fence. She pulled that up out the ground. And so we called the police on her, and the police came out. They really didn't do anything about the situation. So when we saw her on the right side of our property, she lives on the left side of us. She was all the way on the right side of our property that day. And then she started to break off pieces of our wooden property fence. And then she was tying doggy pads to the fence as well. She had a cat tied to the fence. She had her elderly dog on our grass, and she was breaking off pieces of the fence. And that's what caused my sister to go outside to spray her, tell her to get off the property. And I heard all this yelling from the inside of my home. So I came out to see what the problem was, and that's what my sister and Betty Griffin was in an altercation. My intentions were never to go out there to fight her. That was never my intentions. I was going out there to, if you hear yelling and your family members outside and they're yelling and arguing, naturally you're going to go outside to see what's going on. So I went outside to see what's going on. And my sister sprayed her because she refused to get off the property. And she was saying, this is not your property. It's not your property, but it is our property because it was all the way on the right side of our house. Betty Griffin lives on the left side of the property. She was on the right side all the way to our fence on our property line. And that's where she tied her animals. So it was in fact our property. It wasn't a shared gate at all. Her house is on the left side and our house is on the right. And she was all the way on the right side of our property. So it is our property. It wasn't a shared space. So it wasn't just like, we just came out there to beat up on an elderly woman. We had problems with her in the past. We've never had any problems with our neighbors before. None of us never have been arrested. None of us never have been in a fight. So it's just a very unusual situation that we find ourselves in. A very unfortunate situation. We're not violent people. We've never been. My sister have never been arrested. My sister have never been in a fight. I have never been arrested in a fight. We mind our business. It just because of the prior history, that's why it escalated the way it did because of our prior history. It wasn't that today we decided that we was going to beat up on somebody. It was an escalation. She was actually antagonizing us by putting her animals on our property because for what happened the first time, but the police didn't do anything about it. She antagonized us by coming on our property and putting her animals on our grass, and tying doggy pads to the fence. So we're not violent. We're not violent people. I'm not a violent person at all. It's just a situation that happened.
I'm sorry. I apologize. I thought you were finished. Go ahead.
Sorry. I just regret the whole thing. I am very remorseful. It's embarrassing, and because nothing never has happened like this before. Nothing has never happened to me like this before. I've never been arrested before. I'm just really sad and just I'm just very sad about the situation.
All right. Give me one moment. I need to speak with the judge. Give me one moment. Butts, not on the common property line, but she's coming on this other side. And the law, there are special laws for a group of people, for groups of people. There are special laws. There are laws when adults injure children, and then those are usually and generally child abuse, right? There are those laws. There's a whole set of laws for the protection of children. And then there's a whole additional set of laws for the protection of seniors. And you just don't treat a senior the same way you would treat people in between. So if a person in between is coming on your property, tearing down your fence, you still don't beat them up. That's not what the law says. But it's a different process. It's a different way of handling things. But I can't imagine, as I was sitting here listening to Miss Merriweather, immediately, of course, my elderly neighbor came immediately to my mind. And I just was thinking, what if he's...
How strong are permanent teeth from Nuvia Dental Implant Center?
Find out today with our Face Off.
Start trying to pull up that fence that's in between the property. What if he started tying his animals and came around to the other neighbor's yard and was tying his animals? Or what if he tied his animals right here at the part where we can both, sort of enter and exit our property from this one area? And I was thinking, I would immediately try to get in touch with his children. And I would say, your dad, I don't know what's going on. Your dad is, showing me signs that maybe he's not completely there. Maybe there's because he's tearing up the fence and he's tying stuff to the fence, right? I really don't want to, have to get the police involved, but, have you all noticed anything about your dad? Like, I literally would contact his family. It would never dawn on me to spray him with water. It would never dawn on me to engage him physically. In fact, I would have to call his family to say, your dad was physical with me. And I had to just push him away to get away. Your dad was physical and I had to push him away to get away. I hope I didn't hurt him. This is the conversation I'm having with his family if that was to happen. To my no, ma'am, it's my turn. It's my turn. I don't want to hear anything else you have to say. That's what I would do with the elderly person that might be clearly exhibiting some signs of mental illness, of dementia, of all of those things. People exhibiting signs of dementia are aggressive. And what they don't need are people under 60 beating them up. What they don't need are people under 60 coming at them with a broom. What they don't need is two sisters, and I understand the other person has is a defendant. She has not pled guilty. She's not been found guilty. But what they don't need are people attacking them because they're doing things that clearly might be showing that there is some level of mental illness involved. Now, what the charge should have also been is elder abuse. I don't work in the prosecutor's office. As I'm listening, I'm thinking, why did they even negotiate down to this? That's what I'm thinking. When I'm listening, some stuff shouldn't be negotiated. I was watching some case, and the judge asked the prosecutor, are there any offers? The prosecutor said, no, we're not making any offers. We're not reducing this. This got to go to trial. Because there are a group of people that need protection. Those are elderly people, those are mentally ill people, and those are kids. They need protection. So coming in here saying I've never been in trouble, it got out of hand, that says a lot about the person that you really are. And every person has to take an introspective look at what type of person am I really? Because it doesn't matter what type of person you are when the going is going good, when nobody is bothering you. It doesn't matter what type of person you are when a person who when your neighbor is a beautiful neighbor. It doesn't matter what type of person you are, but when your neighbor is not the nicest neighbor, when your neighbor may be exhibiting some signs of some type of mental illness, distress, or just downright mean. If your neighbor is just downright mean and they're a senior citizen, just stay in your house. Call the police, get a camera. Let the family know. Listen, I don't want to have to put your mother in jail. But if she keep doing this stuff right here that's on my camera, I'm going to have to put her in jail because I want the quiet enjoyment of my property. But what we don't do is beat up the people. I remember my mother living in a place, and my mother is hard of hearing, real hard of hearing. That's why I talk so loud. That's why I don't care what people say about how I talk. I don't care. I could care less. They don't know my story. My mother is hard of hearing. She never wore hearing aids until way, way later. So we always talk loud because she needed to be able to hear us. And she wasn't going to admit it was her. So we got to talk loud. And then she moved into a place and she plays her TV so loud because she couldn't hear. And her neighbor upstairs, I don't know if he thought she was doing it on purpose or not, but he started in the middle of the night to get back at her, banging on his floor with something, banging on his floor. And so me and one of my big nephews, we had to go upstairs and let the man know, listen, she's hard of hearing. She's not doing it on purpose. And if you keep banging on that floor, it's going to be a different type of situation. So stop banging on that floor. We're going to work with her to get the TV lower. We're going to try to see if we could get her hearing aid adjusted, but you're not going to keep banging on this floor, scaring our mother and our grandmother. You're not going to keep doing that. That's somebody's mother, sister, auntie, something. That's wrong on every level. This situation is wrong on every level. Every level. Now, I am glad it does appear, I do believe that Ms. Merriweather has remorse. She sounded sincere to me. But then, even after she sounded sincere to me, it sounded like she went right back to justifying her actions and behavior. I mean, an old person would almost just have to be beating me with getting ready to beat me with a pipe or pulling out a gun on me in order for me to attack an older person. I would really have to feel like my life is in danger. And if I went outside and saw my sister beating up the older person, I'm not going to attack the person. I'm going to grab my sister and say, what the heck is going on here? What are you doing? I don't know if Miss Griffin was in the wrong. I don't know if she tore up your fence. I don't know. But if she tore up your fence, there's a civil remedy for that. If she tore up your fence, then we get, it's snowing. Then we get cameras. If she tore up your fence, if she putting her animals on the fence and the animals are in distress, call animal control. Call the Humane Society. Call somebody. These dogs, these animals, y'all come save the dogs. Come save the animals. Right? Okay. So I've said my piece, but this is horrible. Let me just say that to you. This is horrible. The court is going to impose the following sentence. Ms. Griffin, she asked me to impose the maximum extent of the law. I'm not going to. This is your first offense. I'm not going to put you in jail, but I can guarantee you this: you don't have room to not do this probation. Probation is the alternative to jail. Jail is the alternative to probation. Probation is the alternative to jail. Jail is the alternative to probation. I do have one slight problem with the offer, but I'm gonna
Here's why your knee pain keeps coming back, and the easiest way to fix it without pills, shots, or surgery.
All right. The people's offer was 771 if eligible. They had no objection. Probation, even though they put eligible for 771, they recommended 15 months probation. The court is going to do the following. I am going to okay. So the statute indicates that the court cannot delay sentence longer than 12 months. This is what I'm going to do. I'm going to accept the recommendation from probation for a 15-month probationary period. However, I'm going to set the matter for review at the halfway point for the 15 months. So that means she wouldn't be eligible for early discharge until 7.5 months. Then if she doesn't make the 7.5 months, we'll set a probation review. If she completes the probation within the 12-month period that the law says that the court can delay the sentence, then I'll give her the delayed sentence. If she doesn't complete it in the 12 months, then she doesn't get the delayed sentence. So it's kind of a delayed sentence. So we're going to say delayed if completed within 12 months, but the probationary period is 15 months. And then, so that will put a final review date for May the 15th of 2025. And I'm going to set an interim review for, I'm going to actually set a review in July, so we can see where she is, how she's doing. July 3rd, strike it. July 3rd. July 3rd at 10 o'clock. The following terms and conditions: you shall not violate any criminal law of any governmental unit. You must not leave the state without permission of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of your address, phone number, or employment status. You will pay $210 mandatory cost, a $100 attorney's fee, a $400 fine, no restitution, supervision fees at a rate of $35 per month. For the 15 months is $525. Of course, it will be prorated depending on when she gets discharged. A $50 pre-sentence investigation fee. You shall not use or possess any illegal substances. No marijuana without a valid medical marijuana card. No opiates without a valid prescription. No driving without a valid driver's license. Absolutely no contact with the complaining witness. Ms. Griffin, that means you can't go on their property, ma'am. You cannot go on their property. "15 weeks of anger management." I'm sorry, 24 weeks, excuse me. "24 weeks of anger management." I was debating with respect to the mental health evaluation, and I'm not going to order it just at this time. I'm not going to order it. I am going to order random urinalysis for.
This machine could change t-shirt printing forever. I printed this t-shirt with the back.
Judge, it looks like her device is not connecting. All right, I'm gonna. Ms. Stevenson, you spoke to Ms. Bradford in the breakout room, and now she's laying in the bed, attending court. That's so unacceptable and so ridiculous. I don't even know what to say. That's so unacceptable and ridiculous. I'm sending her back to the breakout room. Ms. Ritter, can you call Ms. Griffin? Do you have a phone number?
5 minutes later.
The defendant is charged with 3 counts of assault or assault and battery. Today is the date set for pretrial conference as to each. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Micah Bradford. Ms. Bradford, ma'am, please unmute and tell the judge your full name.
Micah Michelle Bradford.
How are we proceeding?
Your Honor, on behalf of Ms. Bradford, we would first offer the court an apology for Ms. Bradford's prior appearance at the time that this case was initially called. Ms. Bradford, without offering this as an excuse, just wants the court to know she was not lying in bed. She was on her bed trying to charge her phone. That won't happen again. She'll charge her
She
phone
was
the night.
laying in the bed. I don't care what she was doing in the bed. She was clearly laying in the bed. One thing I'm for certain of is that wherever Miss Bradford is, there is a plug that is not at the bed that she could have charged her phone and not be lying in the bed. Second of all, once the court brought to her attention that she was lying in the bed, everybody else that I've ever had came in contact with on the Zoom court that was uninformed enough to come to court in the bed would get up out of the bed when the judge says, you're in the bed. Second of all, the apology should have probably extended from my first encounter with Miss Bradford. Bradford, but you wouldn't have known it because you, I think, was in the breakout room when I had to go into the breakout room with Miss Bradford and admonish her to never speak to me again in the manner that she continued to speak to me, even when she saw that I was the judge. Okay, so anyway, continue, Ms. Stevenson, but she was laying in the bed. She was laying down in a bed.
I said
Ma'am, Miss Stevenson, this because anything you say probably is not going to work out good for you. Miss Stevenson.
Thank you, Your Honor. So, Ms. Bradford, ma'am, if you could just listen attentively to what the court's saying. Your Honor, we don't offer anything, again, as a way, by way of excuse. We just want the court to know that we did have a conversation with Ms. Bradford, that we've had communication with her prior to today's appearance, Your Honor, and this morning, and we would like the court to have our assurances that we are trying to assist Ms. Bradford in having a successful court appearance. On behalf of Ms. Bradford, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Yeah, just the first scheduling for both cases, and I'm going to respect the request.
I'm glad you said that, and before you respectfully request, are these matters properly on the court's docket for pretrial conference? They're a little older cases.
Is that a question for the people, Judge?
For anybody who has access to the register of action.
I do not, Judge.
Just looking at the some of the information I have about the case, Your Honor, about the cases, I do believe these cases are properly on this court's docket.
No, not on my docket. I mean, but on the docket for pretrial conference.
Oh, I would say I have an arraignment date with no prior capious history, Your Honor, on March 1st of 2023.
For both cases?
Yes, Your Honor.
That seems weird. Okay, Mr. Flanagan, can you just confirm that? But all right, so Ms. Ritter, I interrupted you when you said you would respectfully request.
Yes, Judge. So the people respectfully request, if this is correctly set for pretrial conferences for both cases, we respectfully request the court to adjourn both cases for pretrial conference to give the complainant witnesses one more opportunity to appear. They are older cases, Judge, so the people would just like an opportunity to try to locate the complainant witnesses.
Today is the day set for pretrial conference as to each matter. The court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment to give them an opportunity to attempt to locate the complaining witness.
Should these glasses be illegal in the US? Nobody believed me at first, but now everybody wants a pair.
Complaining witnesses. The court will set the pretrial conference for Wednesday, June 14th At 8:36, the complaining witnesses are required to appear. Failure of the complaining witnesses to appear will most likely result in the matters being dismissed unless the people have a valid explanation as to why they cannot appear. Additionally, Ms. Bradford has to come in person. Ms. Bradford is having extreme difficulty in attending court properly. She currently has her hands on her hips. She is not sitting in an upright position as instructed by the court earlier. Perhaps I believe she may have come into the court Zoom late after the instructions were given. And I'm having a difficult time dealing with Ms. Bradford.
When you go to court, you are supposed to act accordingly and dress accordingly, like you're actually going to be present in the courtroom. Doing these things is being disrespectful to the judge, who already has a hard job as it is, and these people are just ridiculous. She's lucky she don't get a contempt of court charge put on her for this.
It's a difficult time appearing via Zoom.
She's the last one.
Mr. Flanagan, mute the courtroom.
Can I just say with the, I don't want to interrupt you, but just the standing up part, that's the only part I'm going to talk about. That may be my fault because when we were in breakout room, I thought it would be better, rather than leaning on the counter to just stand up. What I said to Bradford,
I agree.
Like you're at the podium. So
yeah, okay, I agree. My point wasn't really to,
okay,
and maybe I said sitting and I didn't. Maybe I said sitting. My issue wasn't necessarily with the standing, because standing is what they do at the podium. My issue was with her hands on her hips. And then in response to me addressing the hands on the hips, then she folded her hands in front of her arms, and folded her arms in front of her. But nonetheless, I don't know what to tell you, Ms. Bradford. I don't know what to tell you. You're standing at the podium before the judge, and you just stand with your hands beside you, and you don't yell at the judge, and you don't roll your eyes at the judge, and you don't smack your lips at the judge, and you don't, I don't know. I don't know what else I can say as to how a person is supposed to appear in court. And perhaps my expectations are high, that I believe that the average person should know that when they come to court, they don't yell at the judge. They don't smack their lips at the judge. They don't roll their eyes at the judge. They don't lay in the bed when they come to court. Those are things that I believe people should automatically know, but I could be incorrect. And since I must be incorrect, I'm trying my level best to instruct you on how to appear in court. Now, you can receive the instruction or not, but if you do not know how to appear in court properly on Zoom, then I want to draw your attention to the fact that courtroom right there is open to every defendant that has a case before the court. And you could come into the courtroom and you could stand at that podium and you could have your matter heard. But if you are going to come on Zoom, you are going to come appropriately. And you're not going to treat me like I have done something to you. You're not going to treat me like I arrested you, like I brought charges against you. You're not going to yell at me again. And you're not going to attend court inappropriately. It's just not going to happen. Okay. So like I said, the matter is adjourned to June 14th at 8:36. And the complaining witnesses are required to appear, And if Ms. Bradford needs to come in person in order to attend court properly, then she needs to appear in person. Anything further with respect to this matter?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Bradford. Thank you very much, Your Honor.
You're very welcome, and we are all set until June 14th at 8:36. Have a great day and stay safe.
Well, that's it for today, ladies and gentlemen. That was Judge Lynisse Bryant. I like her. But like I said, if you're going to go to court, if you're in a Zoom meeting, you need to dress and act like you're actually in the courtroom. And doing these things that Judge Bryant says is being disrespectful to her and to her courtroom. Just a reminder, guys, if you like the content that's on this channel, please consider subscribing to this channel if you're not a subscriber and help this channel grow. I would appreciate to see this channel grow. If it doesn't, I'm not going to worry about it. But if you're not a subscriber to this channel and you like the content that's on this channel, please subscribe to this channel and help this channel grow. So I'm going to call this one for the day. You all have a wonderful evening. I will see you guys tomorrow at 3:00 p.m. I think that's Judge McNally. Let me look at the list. Tomorrow is Judge McNally. So tomorrow will be Judge McNally. You all have a wonderful evening. Ta-ta, ciao. I will see you again soon. And try to behave yourselves.
solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.